Hi, I'm Richard Pennington. You know, in the 35 years that I've been practicing procurement law, and that was in the federal side and the state side, even in private practice, I was always a little confused about this topic. We're going to take a few minutes talking about antitrust. You see, I got some of the big points, Sherman Act, Clayton Act, Robinson-Patman, but the hard things for me to understand were twofold. One was, what about some of the distributor relationships? You've probably heard stories of market research discussions, and a contractor would come in and say, well, that's not really my area. That area belongs to someone else. We're going to talk about that a little bit today, and also a little bit on the reporting aspects. What do you do if you think there's evidence of some kind of collusion? You know, this story started really when I saw once again a newspaper article about Google. You know, Google had survived an investigation by the Federal Trade Commission, one of the co-branches of government that investigates and enforces antitrust prohibitions. Several years ago, they had been under investigation by the FTC, and that had closed. And then just most recently, there's a story that the Department of Justice now, who has prosecution authority over antitrust violations, is reopening the investigation into Google. It's important to get this right because I just finished a book on creativity, and Google and some of its practices and its research and development internally is really highly regarded in terms of the artificial intelligence arena. So this becomes very important in terms of what the enforcement agencies do with companies like this. The Google story triggered a memory for me. About a year prior, the Rocky Mountain Governmental Purchasing Association had hosted a conference. They do great conferences, by the way. And they invited a representative from the Colorado Attorney General's office, the Consumer Protection section, that enforces state and federal antitrust laws and investigates fraud. As a featured speaker, they invited an FBI investigator who gave a presentation entitled Lights, Camera, Corruption. I looked at that and realized, I think my confusion is going to be solved. So when I was in the conference with the FBI agent and a representative from the Attorney General's office, the FBI agent actually started this with a discussion perhaps you've seen about the Miami International Airport collusion investigation and prosecutions. Just the short answer was that a purchasing agent in the airport's purchasing office had colluded with a lighting supplier and defrauded the government in upwards of $1 million. And what they did was a series of purchase orders issued for non-standard items by the same person, in some case involving receiving by the persons that submitted the requisition that was in on the fraud. And the kind of dirty paper trail eventually led to the FBI investigation and the prosecution and conviction of several people involved in the scheme. I knew something about, obviously, the Sherman Antitrust Act. It's covered in the legal aspects text in some depth. Also in the NASPO State and Local Government Procurement Practical Guide. It has a very good chapter on anti-competitive behavior, including these. And just to refresh your memory, the Sherman Act arose out of practices in the late 1800s, notably by Standard Oil in Ohio, and led to a prohibition against monopolies and a prohibition against agreements to monopolize or engage in restraints of trade. The important thing wasn't it was an agreement, and that was later modified somewhat in in the early 1900s by the Clayton Act to prohibit specific sorts of activities without the need to show agreements, like tying arrangements where you would force the purchase of one product in order to buy another. There were some initial prohibitions on price discrimination, such as in the case of commodities, offering for sale commodities at different prices to different buyers. I've seen recently that that's been sort of languished in terms of the enforcement of the Robinson-Patman Act, but and the Attorney General actually doesn't do much with that in terms of enforcement. They focus more on the criminal aspects of the Sherman Act as modified by the Clayton Act. The Department of Justice site has some very good materials on antitrust. This quote here shows the difficulty in proving the agreement element of the conspiracy. And because of the secrecy, sometimes they rely on circumstantial evidence that arise out of vigilant purchasing agents, for example, seeing unusual bidding or pricing patterns. The Federal Trade Commission, FTC, has some of the best information on market division or allocation. They have a series of web pages that cover things like dealings in the supply chain and failures or refusals to deal with dealers, for example, who may not follow the minimum price guidelines that a manufacturer imposes. It used to be that these sorts of practices were what they call per se violations of the antitrust, meaning that they wouldn't allow a supplier to come in and claim that there were justifiable reasons for these practices because they needed to, for example, maintain certain price floors in order to maintain the service quality that went along with the product. And in recent years, that's changed. As the series of websites on the FTC sites indicate, there now is applied what's known as a rule of reason. And if I had to summarize it, it's to say that there's a recognition now that sometimes manufacturers do need to maintain certain pricing disciplines with respect to the distribution by retailers or wholesalers in order to keep the services up to par. Otherwise, you end up with people or some companies really lowballing on prices and then sacrificing any of the service support, and then that ends up being offloaded onto some of the other companies that have higher prices and are able to maintain good service. So you'll see in these websites now that there is a rule of reason applied to this. The federal government isn't the only one, however, that has laws. Almost every state has its own version of either consumer protection, unfair trade practice protection, or even some mini antitrust statutes. Just show a few here. The Maryland Attorney General has a good antitrust handbook. California, you'd probably expect, has a fairly robust antitrust enforcement office in the Office of the Attorney General. I dealt with Washington State on 2 occasions when I was with NASPO Value Point, who were looking at some possible, or at least alleged, improper agreements or even price fixing in the case of some electronic components that were coming from overseas. So after the FBI presentation was over and the Attorney General's representative had talked about what their office does in terms of jurisdiction, I still had the 2 questions to ask. And so I went up after the meeting and asked them about market allocation or distributors allocating geographical areas. And the FBI agent was the one that really probably understood this the most and said that, yeah, it is it is a problem, especially if you can prove an agreement between two independent entities. Now, if you've got a vertical relationship by a manufacturer with dealers, it's a different issue. And there the rule of reason is going to apply in terms of how they're allocating responsibility in different areas. So it's complicated. And for that reason, I asked them both about tips and investigations and whether or not they preferred that the allegations or potential violations go through the channels, through the Attorney General's office. And the FBI agent actually said it's really not necessary. And the AG said that really they don't work that much in Colorado in antitrust. They're focused more on consumer protection. But I came away thinking, and still probably do, and this is something you can talk about, that unless in the extremely rare situation that people in your hierarchy and involved in this, and that's going to never happen in most lifetimes, that it's probably good to send this up to channels, to the supervisor management, see if you can talk to your counsel, and then see if they can talk with the Attorney General's office, someone there who may have experience with this, before they exercise their discretion and go to the offices they have relationships with in the United States Attorney's Office and via them to the FBI. Procurement professionals aren't expected to be investigators. However, there are practices that you can follow in order to minimize the chances of collusion on procurements. Some of these you probably know well or already practice. Expand the bidders lists, use market research, use non-collusion affidavits. Many of you already do. Train on the indicators of collusion, either centrally or with other procurement professionals across the agency, and ask questions of suppliers. Follow up with statements or two statements like, that's not our area, with questions like, well, what do you mean by that? Even, I thought there was an issue with that or a problem with that, to try to better understand, not just to satisfy or to find evidence of violations of antitrust statutes, but better to promote or improve the competition. So what are the main points here? Well, I would say be vigilant. Use these practices. And if you have suspicion, run that up the flagpole. Talk to your supervisor, the manager, get permission to talk to your counsel. Try to flesh out what it is you think you see, and then ask them if it might be appropriate to go to the Attorney General's office that handles unfair trade practices or antitrust. Competition is important to what we do as a profession. And these issues are important. And sometimes there are bad things happening by companies and even sometimes employees in government offices. And I think the watchword here is be vigilant. Thank you.